Good morning to everyone. I am Neha Nagendra, pursuing third year BA LLB, your anchor for the inaugural ceremony of the first Lex Vedika Moot Court competition.
Can you be little more audible?
On behalf of Lex Vedika, it is my honor and privilege to welcome you all to the inaugural ceremony of the first Lex Vedika Moot Court competition. At the outset, I extend a respectful and cordial welcome to our esteemed chief guest, Advocate Nipun Saxena. I also extend a warm welcome to our honorable judges whose expertise, experience, and academic guidance form the backbone of the competition. A special and heartfelt welcome. A special and heartfelt welcome to all our participating teams who have joined us from various institutions across the country. Your dedication, participation, and enthusiasm truly reflects the spirit of mooting and legal advocacy. I also warmly welcome Mr. Harsh Verma, founder, Lex Vedika, along with the members of the organizing committee, our volunteers, and the entire Lex Vedika team. Let me introduce the organizing platform, Lex Vedika. It is a professional legal education and academic engagement platform committed to promoting advocacy skills, research excellence, experiential learning among the law students. Through initiatives such as moot court competition, academic conferences, workshops, certificate courses, faculty development programs, and scholarly publications, Lex Verica endeavors to bridge the gap between theoretical legal education and legal practical training. One of its key academic initiatives is the Lex Verica Law Journal, a double-blind peer-reviewed journal with ISSN registration aimed at encouraging rigorous legal research, critical analysis, and high quality scholarly writing. This first Lex Vedica Moot Court Competition 2025 is being conducted in an online mode and has been carefully structured in strict adherence to the established Moot Court Convention and the best academic practices. The competition seeks to holistically assess participants on essential moot court skills, including in-depth legal research, memorial drafting, oral advocacy, and courtroom record. Throughout the competition, the principles of anonymity, fairness, and professionalism, as laid down in the competition rules, are being vigorously maintained. The moot proposition has been thoughtfully curated to engage participants with pressing constitutional questions at the intersection of artificial intelligence, digital governance, and fundamental rights. By addressing issues of privacy, equality, state accountability, and the evolving role of technology in public administration, the proposition aims to foster nuanced constitutional reasoning and advanced advocacy skills among the participants. Here, I take this opportunity to extend a heartfelt gratitude to our knowledge partner Manupatra and our media partner Law Octopus and Kacheri.in, as well as our legal tech partner Law for their invaluable support and collaboration in making this competition possible. A special word of appreciation goes to Burma Legal Council, whose commendable commitment to fostering legal education and advocacy skills among the law students has greatly enriched this initiative. To formally commence today's proceedings and to share the vision behind the academic initiative, I now invite Mr. Harsh Verma, the founder of Lex Vedika, to deliver the welcome.
Thank you, Neha. Very good morning to everyone joining us today. On behalf of Lex Vedika, it is my pleasure to welcome our esteemed chief guest, Advocate Nipun Saxena, sir. Thank you very much, sir, for coming. Respected judges, academicians, members of the bar, faculty members, and all the participating teams to the inaugural ceremony of first Lex Vedika Moot Court Competition 2025. Lex Vedika was founded with a simple but meaningful idea to create a platform that supports serious legal learning while remaining closely connected to practice. This moot court competition is one such initiative that designed to encourage the participants with the serious legal learning, and this moot court competition in one of such initiative that is designed to encourage careful legal research, clear advocacy, and thoughtful engagement with the law. To all the participating teams, I would like to say that while the competition will end with results, the real value of mooting lies on the preparation, the arguments you make, and the experience of engaging with the bench. Every round you argue and contribute to growth of law for the law students and as for your future legal professionals. We are especially encouraged that for this very first edition, we have received registration from 21 teams representing institutions across the country. This response has been truly motivating us and reinforce our belief in the importance of such academic initiatives. I would like to sincerely thank you, our judges, for giving their time and expertise, and our esteemed chief guest for graciously agreeing to inaugurate this competition and share his valuable insight with us today. I also acknowledge the organizing committee whose dedication and teamwork have today's event possible. Once again, I welcome everyone and wish all participants a rewarding and enriching mooting experience. Thank you, and I hope you all will have a wonderful day ahead. Thank you. Thank you very much.
Thank you, sir, for your welcome address and for outlining the academic vision and the objectives behind the first Lex Vedika Moot Court Competition 2025. We now move on to one of the most significant moments of today's inaugural ceremony, the address of the esteemed chief guest, Advocate Nipun Saxena ji. Sir is a practicing advocate before the Honorable Supreme Court of India and regularly appears before various high courts and statutory tribunals. Sir is an alumnus of the National Law University, Delhi, and has closely associated with matters of constitutional and public law significance. His presence with us today truly enriches this inaugural ceremony and adds immense academic and professional value to the proceedings of the first Lex Vedika Moot Court Competition 2025. I respectfully invite our esteemed chief guest, Advocate Nipun Saxena ji, to kindly address the gathering.
Very good morning to everybody. I hope I am audible.
Yes, sir, you are.
All right. Uh, First of all, at the very outset, I must extend my congratulations to Lex Vedika and the entire organizing committee headed by the stellar Mr. Harsh Verma for having organized a debut moot court competition at such a wonderful scale. Right? And I hope and I trust that the competition will bring out the very best in the students who will be participating. It would be an impetus for them to learn something new, to be able to get that command over this very niche area of law. I was very quickly going through the proposition and I was pleasantly surprised to see how relevant it is in today's time. In addition to being something which touches upon a very new area of law, which is, of course, in the background of the DPDP Act, which is just coming to force and the rules made thereunder. I also feel that it has a very inherent constitutional soul within its scheme, right? Because, of course, there are infractions which compel state agencies to bring out new methods in order to scuttle the freedom and personal liberty of individuals. And technological interventions such as apps, which are now floating in the market, are doing their own bidding. Either most of these apps are grotesquely funded by private agencies who then store your personal data, which also is, of course, your sensitive personal data, SPD, right? There are also governmental agencies which are now using that data to further other agendas that they may have, right? I'm just reminded of the 1960s judgment, which essentially was said that every man's home is his castle. right? And that was what you call the saplings of the right to privacy, which gained momentum during the tenure of these two or three fantastic judgments that were passed in quick succession. One, of course, during the time of Kartar Singh. Another was a watershed moment during the time of imposition of Misa, where a particular person was taken out of their house in the middle of the night, and an Article 226 petition, a habeas corpus, was said to have been maintainable, as also on the grounds of violation or infringement of right to privacy. The final watershed moment, I would say, was PUCL versus Union of India, which was the famous wiretapping case, in which the governmental agencies uh, exercised what you called an uncanalized, unfettered discretionary power to tap into a person's device and seek to hear information only on the basis of a suspicion that a person may or may not be involved in some illegal activities. Right? It was in these different decadal judgments that outlined different contours of the right to privacy. Of course, then came the famous Aadhaar case, the Justice K.S. Puttaswamy judgment, which decided to forever lay down the law that right to privacy is an inherent, inviolable part of the Constitution. It is inherent to Article 21, Article 19, facets of Article 41, and right to privacy cannot be, in that sense, uh, taken only from one article. Right? It is a theme which flows throughout the length and breadth of the Constitution and different parts of it. Of course, to the new time mooters, or I don't know whether they are slightly seasoned ones, I would say that this is an excellent opportunity for you to bring out the best. You see, as practitioners now, what we really miss the most is this time that you had to prepare. Right? As practitioners, and I'm sure Mr. Verma would agree with me, that we rarely get the kind of time that you guys have been given to sit down and go through a problem, a moot proposition that was given to you. And I'm sure it would have been given to you at least a month or 2 months before, giving you ample time to prepare. Right? And I cannot understate the importance of such activities. What it essentially does is that it develops 5 to 6 skills. The first of which is it teaches you the value of industry, hard work, right? And industry is not just hard work, it is hard work which is intertwined with discipline, right? Industry is the backbone to litigation. And of course, as would be in other areas of law too, but since I hail from the litigating sector, I would tell you that it is quintessentially important that you are industrious first and foremost. The ability to put in many hours of hard work is what is being expected of you. Now, the one good thing is that what litigation is, and maybe what comes out during arguments and counter arguments and rejoinder submissions, is what the Germans used to call blitzkrieg. Blitzkrieg essentially means lightning fast. You have to be on your toes, you have to think on your feet. You see, in World War II, when the Allied forces were fighting against the Axis forces, the German planes had only very little fuel, which could sustain a targeted bombing in London, and they had only 10 minutes to do that because they had to carry enough fuel to do it, right? So it was only in that period of 10 minutes that they used to bomb and get back. If they missed that window of 10 minutes, they would have lost the plot. And that is very much so during the submissions that you canvass in your moot courts, right? Mr. Nariman used to famously said that the best kind of arguments are the ones that came to me after I had argued the matter and was sleeping. And then I used to get up and say, oh shit, I could not argue this point of law, right? Any litigator will tell you that the best of submissions that they could have conceptualized or that they could have formulated, or the best propositions that they could have canvassed or advanced, are usually those propositions that occur to them in the night, right? After they had argued the case. So please do not lose hope or heart if you come across something which is so basic. Because as Mr. Seaver used to say, you read a brief 20 times, and the 21st time that you read the brief again, you will be very vitally surprised as to how new points come and occur to you. And I think this is the beauty of this profession in that sense, that the same moot proposition that you may have read right now, that I may have read only now, would give me only a bird's eye view. But to you people who have had that moot proposition for about a month or 2 months, and some of you who are passionate about mooting would be sleeping, would be taking this to your bed chambers, this moot proposition will bring out the best in that sense. Right? Because every single time that you decide to dive deep into it, you will find something new that captures your imagination and makes your brain work. Which brings me to the second super skill set that you require in mooting, which essentially is critical thinking. Right? Critical thinking is also intertwined with something which is called active reading habit. Right? As lawyers, we are supposed to go through 2,000, 3,000 pages of judgments every day. An ordinary lawyer is somebody who reads at least 1 to 2,000 pages every day when they are preparing for a matter. To be able to churn out the essence of something which runs into thousands of pages cannot be left to an AI enabled tool. It has to happen from your own brain, right? And this is something that I also am very conscious, and I take this platform and opportunity to apprise you that your essentially your reliance on applications or AI enabled tools must be limited so that at your age you are not completely consumed by all that it has to offer. It is one thing to say that you have read something on your own and then sought some assistance from AI to see what exactly it entails. But it is wholly other thing to first type your query on an AI chat box and then be able to carry out your research as directed by AI. You know, what happens is that one of the most stellar advocates, Mr. K. Venugopal, always used to make all his juniors and interns read judgments. He used to say, okay, go to 1976, pull out an AIR manual, you would find this proposition there, and I need all the judgments. For all the judgments, you had to sample out many judgments that were irrelevant to you at the point of time, or let's say you were irrelevant to the mood proposition that you had. However, in such scenarios, what happened was that uh, one essentially stumbled across those judgments, which may or may not be relevant to them today, but which were most certainly relevant to them, let's say, going forward, right, in life. Similarly, a next skill that comes to my mind is teamwork. Mooting exercises, just like litigation, are all about teamwork. Gone are the days, and I hope that trend is no longer there. Back when I was a student, speakers used to say that, researching is drab work, and only researchers get to research. Whatever the researchers bring out, that output can be argued by us counsels. You cannot be farther from truth. Many a times during moot court competitions, speakers were unable to respond to the queries of the bench, and therefore we requested the researchers to assist us because the researchers tend to know infinitely more, right? Therefore, mooting is a zero sum game in that sense, because while it enables the speakers or it hones your rhetorical skills, it also is equally important that your researching skills are given much needed impetus, right? In addition to that, I think what is most important, apart from the mooting activities, is that I would also take about 2 minutes time to deal with the intersection of technology these days, right? One of those things is that with an increased uh, status on increased impetus on digitization, on new application based procedures that have come out. Say, for instance, the Sarthi app, the Sampark Sarthi app, as you would find, the DPDP Act of 2024, and the provisions of the IT Act, one would get to see that there are that the entire lifespan of a human being is completely encapsulated from all sides through this process of digitization, right? I wish every organizing committee member the very best, all the judges. My heart goes out to you, and to all the mooters, new and otherwise. I wish you all the very best, and Godspeed on this wonderful initiative. Thank you so much.
Thank you, sir.
Thank you very much, sir, for your insightful and inspiring address. Your words will undoubtedly guide, motivate, and inspire our participants throughout the competition. With your due permission, I hereby declare the first Lex Vedika Moot Court competition to be inaugurated and open. We extend our best wishes to all the participating teams for a stimulating and successful competition, and we hope the rounds ahead provide a meaningful platform for learning, advocacy, and academic excellence. This brings us to the end of the inaugural ceremony of the first Lex Vedika Moot Court Competition 2025. Participants are requested to kindly join the preceding link that has been shared so that you may be shifted to your respectful virtual courtrooms for the commencement of the competition. Thank you and wish you all the very best.
Thank you, everyone. Thank you once again, sir. Thank you very much, sir.
Thank you. Thank you so much. All the best
Thank
to
you.
all the participants.
Means a lot to me. Your presence means a lot, sir. Thank you.
It's my pleasure. It's my pleasure.